and prospects. Let's listen to the senior advocate.
As you can all see, Barrister Abeng's trouble is too much. Far, far too much. Too much. The governor of the Littoral Region, represented by the Secretary General, the President of the Cameroon Bar Association, my dear brother Eric Mba, President of DALAS, our great host, past presidents of the Cameroon Bar, and especially my brother Ngalle Monono, members of the judiciary present, the Consul General of the Federal Republic of Nigeria to the Cameroons, all colleagues of the legal profession, and especially our colleagues of the DALAS, President of the Law Dinner Committee, friends and colleagues, ladies and gentlemen. It really is an honor, and I must say a true honor, to join you at this 2024 DALAS Law Dinner. And I am extremely grateful to my brother, the President of the Bar, Eric Mba, the executive and entire membership also of DALAS, and of course the chairman, the president of DALAS, for the kind invitation to be your guest speaker today. But before I go on, I must say that the choir was absolutely excellent. I wish I had some money. I would have taken them all the way back to Nigeria. They're an excellent choir. I must also say that this is a very wonderful opportunity for a reunion with some of my classmates and friends from our days at the University of Lagos 49 years ago. This year will be 46 years since we graduated. And of course, we started out at the University of Lagos in 1975. We made it 49 years. And we graduated in 1978, which is about 46 years. And I'd like those of them who are here to stand up. My brother Ngalle Monono. And then Beltha Epie Sume, who is there also. And as you can see, Beltha doesn't look anywhere near 49. Thank you very much. And Ikomi isn't here, Ikomi Ngongi, he's not here, but I'm sure that hopefully we'll see him sometime tomorrow. But just a year ahead of us, at that time at the University of Lagos, was the legendary Mrs. Lucy Asuagbor, as she then was, who later on went on to become the president of the Court of Appeal, and then went on to the Supreme Court. She was the first person ever to obtain a first class in law at the University of Lagos. So Mrs. Asuagbor is a legend as far as we are concerned, those of us back in Nigeria, and certainly at the University of Lagos. I've chosen to speak on some aspects of the theme, legal practice and investments in Sub-Saharan Africa, challenges and prospects. Legal practice and investments in Sub-Saharan Africa, challenges and prospects. Our world is changing very quickly, sometimes much faster than we notice, much faster than we can cope with. It took 250,000 years, 250,000 years, for the world to reach a population of 1 billion people. 250,000 years. But it took less than 20 years to add 2 billion to our population, and now we're 8.2 billion. 250 years to get to 1 billion. 20 years to add another 2 billion, and now we're 8.2 billion. Just to show you how quickly things move. In the past 30 years, more has changed than in the past century. And in the next 30 years, more will change than in the past 2 centuries. For some of us who were born in the late 50s and the early 60s, we've lived through analog, digital, and now intelligent systems. Systems that are able to make decisions without human intervention. Legal practice that we're all involved in is changing like crazy. We are holding on to the last vestiges of legal practice as we know it. In another decade at most, we will not recognize legal practice as it is today anymore. We certainly will not recognize it. Recently, I was speaking to the management, a new management of the law firm which I co-founded and from which I'm now retired, Simmons Cooper Partners in Lagos. They were showing me the new artificial intelligence-driven tools, the AI-driven tools that they now use in the firm. They now have a ChatGPT interface that within minutes can sift through several legal databases and offer legal opinions on statute and case law. What used to take days of research can now be done in minutes. And the system is intelligent enough to argue with you if you oppose its point of view. They also have a tool called the GitHub Copilot for legal drafting. It uses the firm's own database and other databases to draft practically any type of legal document, from simple documents, simple contracts, to the most complex shareholding and multi-party, multi-jurisdiction contracts or investment documents. And it can suggest language of the specific clauses tailored to whatever legal document you want. They also have an AI chatbot that even when the firm is closed, can give immediate responses to common inquiries from clients. And these tools are getting smarter and smarter every day. The incredible thing about these systems is that they are capable of critical thinking, using huge data resources faster than the human mind. It is clear that what we used to hire a good number of lawyers for is no longer necessary. It's now being done much faster and more accurately and more thoroughly by technology. And these systems don't get tired, they don't go on leave, they don't ask for a pay raise. They are just, as you know, mechanical. And you know these tools are becoming cheaper and cheaper. Like mobile phones at a time, we thought only wealthy people could carry mobile phones. Today everyone has a mobile phone. And that's what's happening to these systems. They're getting cheaper and cheaper, and they're available everywhere. The second point of change that I'd like us to take into account is the role of the lawyer. The role of the lawyer today. That role is changing very rapidly. You can no longer be a technistic lawyer. That is to say, a lawyer who just says Section 2 says this, Section 4 says that. That sort of lawyer is practically going completely dead. In the next few years, you won't have that kind of lawyers anymore. And this is for two reasons. The first is that we now have technology, as I've explained, which is fast replacing basic legal analysis and opinion writing. Many clients will be able to do this themselves using AI tools. And second, to be globally competitive, because we have to be globally competitive now. Everybody is online. The world is flat. Everybody is operating from the same hymn book. To be globally competitive, a lawyer advising on foreign investments, including cross-border investments, needs a good working knowledge of global economic trends, global rules, even geopolitics, as they influence international trade and commercial transactions. For example, an understanding of how macroeconomic conditions such as interest rates, inflation, and exchange rates can impact the client's business and operations is crucial. Exchange rate fluctuations and currency volatility may lead to serious financial exposure for the client in cross-border transactions. So to advise these days, a lawyer must advise on compliance and risk mitigation strategies. And that is now the business of the commercial lawyer. So the commercial lawyer today must be a man or woman of affairs, a global professional with an understanding of how the global financial industrial complex works. He or she must in fact be able to put deals together. You can no longer just be an advisor. You must have the capacity to put the deals together. And the reason why you must be a person of affairs and not just a lawyer giving advice is because most of our cake, a big portion of our cake as lawyers, has been bitten off by technology. And more will be eaten up very soon and very quickly. Years ago, you could make money from writing a learned opinion on doing business in Cameroon. I mean, I remember years ago when clients would send us requests doing business in Nigeria, and we'll charge good money. Nobody is doing that anymore. Today, your client can do that himself or herself using ChatGPT or any of the other AI tools. And even lawyers who think that they're doing only national or local practice, the days of such lawyers are also numbered. If you're saying, oh, all I'm doing is national practice, just local practice, I'm not involved in all that commercial, international, your days are numbered too. We now have the rise of online alternative legal service providers. They're not very popular yet, but they're becoming very, very popular. They are called ALS, online alternative service providers. They just use technology to provide more affordable legal services, and they are gaining ground. So they are jurisdiction agnostic. They don't have any jurisdiction. They can advise on any law anywhere. If they're interested, for instance, in the practice in DUOLA, they will offer cheap tenancy agreements, whatever type of agreements there are, and they will just do them online. You pay a simple fee. So today, if you look at a lot of in-house legal counsel all over the place, especially these accounting firms and all that, they are using alternative legal services providers already. And they're using them for legal research, document review, and all that, regulatory compliance. The question of their legality is, of course, open. So, for example, let us say, for instance, that somebody gets a legal document and just looks around. Why should I give it to a lawyer? I can send it off to these alternative legal service providers. It is all technology. They will give you this. There will be a proper document review, point out to you what the problems are, what the difficulties are, and all of that. So lawyers are going to get less and less relevant. We've got to step up our game. We simply have to step up our game. Now, how about the African Continental Free Trade Area agreements? Now, this is by far the most consequential commercial industrial investment treaty in the history of our continent. The agreement, as you know, creates the world's largest free trade area by number of participating countries. It's not necessarily the largest free trade area, but by number of participating countries, because we have 54 countries participating. That's the largest free trade area by number of participating countries. A single market of over 1.3 billion people and a combined GDP of 3.7 trillion US dollars. That's the size of the common market of the African free trade market. The simple objective of this free trade agreement is to enable African countries trade in commodities and value-added manufactured goods, and then also free trade in services across the continent. That's also a simple reason why we have this agreement. The agreement is backed by Afro-Exim's PAPS, the Pan-African Payment and Settlement System. Now, this system is very important, and also MANSA. PAPS is a system that enables African countries to trade with each other in our own local currencies. So we don't have to change our currencies to dollars to trade with each other. You can buy my Nigerian goods in Kenyan shillings online. So what PAPS does is to enable the settlement of these payments so that buyer and seller can receive value in real time. And that's what this payment systems is about. Then MANSA is another technology device which was introduced also by the Afro-Exim Bank, and is also to support the Africa Free Trade Agreements. And MANSA is a digital due diligence repository. It's a single source containing information on African companies, financial institutions, small companies, SMEs, and all that. The purpose of the MANSA is to store information about African entities, companies, and all that, to enable potential investors or trading partners to perform customer due diligence and know your customer checks on African companies and entities. So once a company is registered on MANSA, any investor anywhere in the world can do a due diligence, can know what they do and how they do, what sort of bank, which banks they use, and those kinds of things. Now, the next question, of course, is what will the full implication of the implementation of the Free Trade Agreement mean, especially for legal practice in our countries? What type of opportunities for legal work will it present? And what is the current state of implementation of the agreement? The international trade and commercial law issues that arise are very many, and they're huge. And as I said, as I said to the practice section of the Nigerian Bar Association, because I was speaking to them about the AFCTA as well, the bar must pay more attention to what is going on, especially the rules that are being negotiated, because these rules are going to have far-reaching effects on local and foreign investments and commerce in all of our countries. So the bar associations, including our friends in Dallas, every one of the bars, the Bar Association of Cameroon, the Bar Association of Nigeria, must pay more attention to what is going on, the negotiations that are going on today on the free trade agreements, because they're going to have tremendous effect. What are some of these issues that we need to pay attention to? Today, negotiations are going on intellectual property rights, protections for trademarks, copyrights, patents, because nations often have different levels of enforcement and protection of copyright, of intellectual property. So ensuring fair protection while accommodating different enforcement standards can create conflicts, particularly if the IP laws in one country are seen as inadequate or overly strict. All of these issues are now being debated. There are dispute resolution mechanisms that are also being developed, especially for market access and tariff disputes. And for instance, under the Guided Trade Initiative, one of the things that's happened with the free trade agreements is that there was a guided trade initiative, almost a test run of how the free trade agreement will work. And what was found was that some countries imposing non-tariff barriers such as quotas, subsidies, or stringent customs procedures can lead to trade conflicts. And there were several conflicts that were discovered in the process of this test run. So there are critical rules that have to be dealt with. And as I said, the bar simply has to pay attention. There are also rules around what is called rules of origin. Now, rules of origin are important to determine where a product was made, because that affects tariff eligibility. Because what the free trade agreement means is that we're going to open our borders to free trade. And that means that the Chinese, for example, may want to take advantage. And what would they need to do? They would take their products. For example, in Nigeria, they could take their products to Benin Republic, and they want to export to Nigeria under the free trade, no tariff rules. What we want to promote is not Chinese dumping. It is indigenous value-added manufactured goods. So by the rules of origin, we will not allow Chinese goods, even if they are coming from Benin Republic, because they did not originate or were not manufactured in Benin Republic. So these are some of the issues that are coming up now under rules of origin, and there are all sorts of discussions that are going on. There are also issues on digital trade and data privacy, including data flows, privacy and cybersecurity standards, and all that. Digital trade and commerce, as you know, is taking over international commerce. A lot of commerce is going on online now. And then digital payments, blockchain-based transactions are now commonplace also. So all of these types of transactions are being debated today. These are the sorts of questions that are arising as countries are negotiating their way through the trade agreements. And as lawyers, we must be able to advise on compliance with the various regulations on data security, on intellectual property rights across multiple jurisdictions. So a good knowledge of how the free trade agreement works will enable a lawyer anticipate how these new rules will affect their clients' supply chains, pricing, market access, and all of these things. These are the kinds of value-added roles or value-adding roles that the lawyer today must take on to maintain relevance and control of transactions. We simply have to be familiar with these rules in order to be able to advise appropriately. Now, but then there are also issues about how free trade agreements will affect legal practice. And I think that again, this is something the bar has to pay attention to. In our various jurisdictions, negotiations are going on now about the protocols and regulations for the Protocol on Trade in Services. The aim is to liberalize services across the continent, including professional services like law, medicine, engineering, accounting, and others. So what is being negotiated now is a protocol establishing the framework for reducing barriers to cross-border provision of services. Now that would broadly include the free movement of professionals. So member states have been submitting what is called schedules of specific commitments, detailing the services they're willing to open up to foreign competition. However, there are many countries that are still negotiating the exact terms, including the degree of liberalization for specific sectors and services, such as professional services. So the real questions that are arising now in those negotiations is how much should our own country open up its legal practice, for example? Will the big foreign firms not take all the work if we open up our legal practice? How about the country differences in educational and regulatory standards for different professions in different countries? How will these be accommodated? But I think it's important to bear in mind that whatever the obstacles to free trade, the free movement of professionals, the free practice of professionals, whatever those obstacles may be, we must remember that the removal of barriers is the ultimate objective of the free trade agreement. And so it will serve professional associations well to prepare their members for a world in which you can practice across Africa and have other African professionals come and practice here. Our law associations must pay attention to the transformative discussions that are going on under the free trade agreements to avoid any surprises. Let me now talk very quickly about climate change and the opportunities for foreign and local investments. First, a very brief background. As we all know, the simple explanation for the climate crisis is that the emission of fossil fuels predominantly by industrialized countries, historically and cumulatively, is the cause of the imminent disaster that is called the climate crisis. It is because industrialized countries mainly polluted the environment with fossil fuels while industrializing that we have a climate crisis. So, by the Paris agreements, of course, these are the wealthier countries coming together with the rest of us, the world agreed that the only way to avert a disaster is that by 2050, the world has to stop using fossil fuels and undergo a transition to renewable energy. African countries, as we all know, are the least emitters of these dangerous gases, but we are the worst hit by the effects of climate change. And the African continent is warming faster than any other continent on the face of the planet. And we are the least prepared for the devastations of climate change. Also for us in Africa, there are two existential threats, not just one. So for us, it's not just a climate crisis. More importantly, we have a poverty crisis. And a lot of that poverty is caused by energy poverty, a lack of electricity. Over 600 million Africans have no access to electricity. Another 150 million have irregular access to electricity. Over 1.3 billion people, 1.3 billion people on the African continent, that's the whole mass of us, are serviced by an installed capacity of 244 gigawatts of power. 244 gigawatts of power, that's 244,000 megawatts of power. Now that is less than the 248 gigawatts of power available for Germany's population of 83 million people. So we, 1.3 billion people, have available 244 gigawatts of power. Germany, with only 83 million people, has 248 gigawatts of power available for its 83 million people. So you can imagine the sort of disparity that we're talking about. But for Africa to develop its economies, we must use energy. However, the world has a major dilemma. If Africa were to develop in the same way that the industrialized countries did, that is to say, using fossil fuels, we will become the largest emitters of dangerous gases by 2050. But what is more, the world will never be able to achieve its net zero targets by 2050. So if Africa goes the same way that the wealthier countries of the world, the industrialized countries of the world developed, then it will be impossible for the world to achieve net zero by 2050, and the world will face a disaster. So, to cut a long story short, the world needs Africa to develop without increasing emissions. And I want to repeat that. The world needs Africa to develop, industrialize, without increasing emissions. That is, using renewable energy for its development. So Africa now stands in a position where it can be the nemesis of the world or the solution to the climate crisis. And it's very important that we bear this in mind because it's a very strategic position that Africa finds itself. We can either be the nemesis of the world if we choose to go the way that the industrialized world has gone, by using fossil fuels for our development, or we can be the solution by using renewable energy. In September 2023, at the Africa Climate Summit in Nairobi, the Africa Union endorsed the Nairobi Declaration, which meant that we also endorsed the resolution that Africa would adopt what they described as a climate-positive growth paradigm, or simply a green pathway to economic growth. Why? Why is it important that we develop a green pathway? It is because there is a massive economic opportunity if we do so. We have a massive economic opportunity because we are the most climate competitive region on the planet. And the places in the world that can provide green solutions most cost competitively have a lifetime economic advantage as the world cuts down its use of fossil fuels. Thanks to Africa's abundance of high quality untapped renewable energy, we have 60% of the renewable energy capacity potential of the world. We have a young and entrepreneurial workforce. And we also have the relevant critical assets. We have almost 40% of the critical minerals that the world needs. We have the key ingredients to be a major climate action powerhouse. So Africa can develop using renewable energy and provide the millions of jobs that our people need. But we need at least 4 elements to successfully use climate action for the development that we have in mind. The first is that African countries must focus all their economic development plans on climate-positive growth. That is to say, that in writing our economic development plans, we must have this green pathway in mind. We must have a sense that we want to develop along the green pathway because we are competitive. We are more competitive than anywhere else. The second is that we must develop and implement legislations that support a green economy, legislation and regulations. And these are issues, of course, that will concern us as lawyers. The third is the role of wealthier countries. Wealthier countries must realize that we are doing them a great favor. And I think that is becoming very apparent because from all of the discussions that are going on in the world today, It is evident that if Africa does not play the role that we are talking about, the world can never achieve its objectives and the world faces a disaster. So they must recognize that we are in the driver's seat in these negotiations, and they must provide appropriate and sufficient finance and investments in Africa's renewable energy infrastructure and open up markets for our green products. Today, there are legal and trade issues around all of these problems. There are many legal and trade issues. First, I think that lawyers, especially trade and investment lawyers, must get involved with our ministries of justice in ensuring that these new rules to create an environment for attracting green capital are made. It is important that we as lawyers, especially those of us who are in the trade and investment area, this is a unique opportunity. And a lot of African countries are taking advantage of it. Lawyers, especially trade and investment lawyers, are taking advantage of this. And we must work with our ministries of justice. Now, we must also recognize that attracting green capital, we need local value-added manufacturing using renewable energy. That's one of the critical issues. Happily, today, over 42% of African countries outside of North Africa have legislation already preventing export of raw ores without processing. And that is to say that today, at least 42% of Sub-Saharan African countries now have legislation that say you cannot just simply take iron ore and ship it abroad. You must process it. There must be local beneficiation so that in the process of adding value, you create jobs, create opportunities, and all that. So all of these sorts of legislation are important, and we must continue to promote these sorts of legislation if we are to benefit from the green energy boom that we're going to see. There must also be legislation on the mandatory use of renewable energy for processing and manufacturing. This is very crucial. Legislation must point investors in the direction of using renewable energy for manufacturing. And if you look at the figures, we won't have any time to look at all of that detail. Renewable energy is becoming cheaper and cheaper every day, even cheaper than fossil fuels. It's getting cheaper than gas. So the possibilities are open, and renewable energy is right where we are. It's right here on the continent. There's also some concern around some European trade rules and all that. And these are some of the issues that we have to pay attention to, again, as lawyers. There is what is called the Carbon Border Adjustment Mechanism, CBAM. Now, this is a European, another of the European barriers that has been created for exports into Europe. Now, never ever imagine that these regions of the world are not going to look after their own interests. They're going to look after their own interests, which is why it's so important that African lawyers in particular work together to look after the interests of Africa. So the European Union has this CBAM, this Carbon Border Adjustment Mechanism, which puts a carbon tax, a carbon levy, on exports coming into the European Union. And then they also have the EU deforestation regulations. It places a levy on export produce that is the product of farms in deforested environments. Commodities such as soy now, palm oil, wood, coffee, cocoa, rubber, and beef are going to be affected by this legislation. So both of these legislation obviously disproportionately punish African exports. So we've got to have, take all these into account, especially as we advise and as we negotiate. Another opportunity for investment and trade, which also as a result of the energy transition, is the establishment of carbon markets. And I think it's very important, again, for us to bear this in mind and to actively look for ways of benefiting from carbon markets. Now, a carbon market is simply a trading system that enables countries or companies, even individuals, to buy and sell carbon credits. That's what a carbon market is, just a system to enable individuals, companies, anyone, to buy and sell carbon credits. Now, what is a carbon credit? A carbon credit is a right to emit a specific amount of greenhouse gas emissions. In other words, it's a right to pollute the air, or you pay for it. So an airline, for example, if you look at many of the airlines, every one of these airlines coming from different countries already have their carbon limits. They have the carbon limits that they must observe. But a lot of them obviously will exceed those limits. So what they do is that they buy carbon credits so that they can exceed, in some cases, those targets, but they pay for those targets. So they pay for those credits. So the whole idea of paying for the credits is to discourage pollution, and of course, this is calculated usually as a volume of the carbon emissions. So how carbon credits is calculated, is that if, for example, you have a product, you have a project, say, for example, a deforestation project, if you're able to show that in this deforestation project, I am going to be able to save 1,000 units of credit, of carbon, then you can price it and sell it to those who need the credit. So this generally reduces the calculated volume of carbon emissions and all that. And carbon credits themselves are created by these things I've described, carbon reduction schemes. For instance, in Nigeria, there's a scheme on decommissioning of diesel generators. So if you, of course, in Nigeria we have a lot of diesel generators because of the power situations and all that. So if you decommission a diesel plant, for example, you save some credit, and you can sell that credit as on the carbon credit. The integrity of the credits that are being created must be verified by verifying agents, and the carbon also must be well priced to attract both producers and sellers and buyers, beg your pardon, of carbon. The creation of a carbon market and all that it entails will call for appropriate rules and regulations and dispute settlement mechanisms. This is where the business of lawyers comes into play. The carbon market activation in Nigeria, for example, is an active playground for lawyers. And of course, as you can imagine, lots of lawyers are looking for the opportunities there and being able to gain opportunities. But before I leave the point and I'm rounding up, I think it might be important to warn, in this whole process of creating carbon credits, that we need good skills to negotiate carbon credit transactions. We need good skills, and we need for our countries and our governments to pay attention to what is going on, all over the world. International companies today are buying up forest lands in Africa for carbon credits. A lot of forest lands are being bought in Africa today by many international companies in order to use them for carbon credits. How? So they negotiate for forest lands with countries. They ask a country, come to Nigeria and say, we'd like to buy several acres of forest land. And the whole idea is that they conserve the forest land. They don't allow it to be used for farming for any such thing. But then that translates to carbon credit, because if you conserve forest land, you actually save carbon emissions, and you're able to make money from it. Now, this is what is called carbon avoidance, an example of the carbon avoidance project. But as of today, many African countries have sold huge tracts of their land. A company, a UAE company, bought 20 million acres of land in Zambia. That is the equivalent of 10% of Zambia's landmass. Another company the same company bought 18 million acres in Zimbabwe. That is the equivalent of 20% of Zimbabwe's landmass. That same company bought 20 million acres in Tanzania. That's the equivalent of 8% of Zimbabwe's landmass. And the same company bought 2.5 million acres of land in Liberia, about 10% of Liberia's landmass. So, as you can see, if we are not careful, before we open our eyes, we would have sold everything. We would have sold all our land. The question, of course, is what sort of negotiations go into these land deals? We have to pay attention. We have to know that these things are going on. And we've got to be able to say, especially lawyers, have to be able to say and advise our governments that if you sell land today, what are the parameters? How are you selling this forest land? And in what way are we benefiting? Let me conclude by saying that our profession is known for its conservatism and its traditions. And these are good attributes. Good to be conservative, good to be traditional. But every generation will have the burden and challenge of responding to change. Some generations bear a greater responsibility because of the sheer speed and enormity of the changes that are taking place. We are one such generation. Our profession is in that moment in history, and we must live up to the challenge. We have no choice, because the changes that are taking place now are so swift and so quick, and the implications are so vast for our people and for our future that we must pay far more attention than we're paying. And those of us who belong in the legal profession have a very, very important role to play. So I wish DALAS many more years of thought leadership in legal practice and many more busy and prosperous years. And I pray for all of you that God will prosper the work of your hands and give you excellent health to enjoy the fruits of your labors. Thank you very much.